Good. I guess real quick. Hi, folks. I'm Zenith of the DGen Roundtable, bit of a legal and government analyst over there. Did about 5 years in the Coast Guard doing some contract enforcement and also the sexy job of chasing drug runners in the Caribbean, doing international maritime law enforcement. But I'm not the heavy hitter. That is actually this gentleman right here, Mr. Herbs. Who are you and what's your background like?
I'm nuclear herbs. I practiced law for about just over 20 something years. So, did a lot of litigation, just decided to, put my powers to good use and, to try and help the community understand the whole Richard Hart case when it got filed. And, we got some good information on that today. About time the judge finally ordered the entry of the dismissal. So and that's basically the final step is like the judge did she ruled on the motion, and just to be clear as to what happened, the judge ruled on the motion and dismissed the SEC's claims against Richard. But in order to formalize essentially close out the case, formalize it, there has to be a formal written order. And that, once we kind of expected that to happen really quickly after the SEC said they weren't going to file an amended complaint. But, courts do things at their own pace, as we very well know. And, it took 2 weeks, but she finally ordered the clerk to do it. So I guess now it's wherever this thing lands in the clerk's inbox is when it's going to get done. So hopefully they don't have very much in there. I mean, it's really not a complex procedure. It's just basically a 1-page document saying the case has been dismissed, and there's some official language in it, and that basically starts the 60-day clock for the SEC to file a notice of appeal. But it just seems really unlikely at this point that they're going to do so. I mean, they didn't even bother to amend a complaint. There's not really an issue of law that got addressed wrong in her order. So I just don't see any viable appeal options for them. So just hang the 60 days and we're good, I think.
Sounds good. I guess as a quick recap, yes, we did have the SEC drop their original complaint on July 31st, 2023. It took about 2 years to get all the way through the process, but we had oral arguments back in November in New York City for the Second Circuit Court where this took place. And then after that, I want to say it was February where we actually got the entering of Judge Amon's decision to officially dismiss the case. Since then, we had the extension periods that Mr. Herbs mentioned, and now we officially have it in the record. So 60 days. I know it's a bit longer than 2 more weeks, but 60 days to file an appeal. The good news is that an appeal is really not, you can't really file one against whether or not you like the outcome of the case. You have to pretty much say that the case was not handled properly. And by all accounts, I would say this one was done very much by the book.
That's accurate. The appeal can only attack legal issues. You can't introduce any new facts. You can't say, well, we didn't get a chance to argue this at the trial court level. You can't bring up anything new like, oh, we just found this old video of him saying, whatnot that might have helped us in the trial court. You don't get to go there. So you basically have to say the judge analyzed the law wrong. The facts that she had, she applied them to the existing law wrong. And that's why we're appealing. And that just honestly didn't happen here. The law in personal jurisdiction is not new. It's been around quite some time. It started basically in the 40s. Got a big kind of a big expansion overhaul in the 80s. But this is nothing new. This judge has seen many, many, many cases with personal jurisdiction law, and the analysis is spot on in my opinion. So I think we're good here.
Excellent. By the way, I know that myself and Herbs, we are US based, but Mad Dog, I believe you mentioned you are UK based, correct?
That's correct. Yes.
Excellent. So slightly different systems about how everything works, but the good news is that U.S. law is primarily based on good old English jurisprudence.
Absolutely. Yeah. One of the first cases I studied in law school was Regina versus Dudley and Stevens. It was like a 1600s, 1700s case, and I think it was 1600s where there's like a murder case from good old England that because we borrowed a lot of your law.
Absolutely. But I think the great thing about yourself, Nuclear, is what you've brought to the PulseChain community is an actual interest in law, and people actually taking note and taking an interest in the law. And a lot of people prior to this is they obviously look at the law and say, "Oh, boring, yeah, not interested." But this is actually when you've got the law and it affects yourself, and you can actually read into it and look into it. And I think it's brought it all together. And again, along with the crypto industry as such is like, yeah, let's fix the money, but also you need to learn about all these other things as well. Learn about the law and how you can protect yourself once you've got your crypto wealth. So it's all part of the same bucket, really.
Yeah, absolutely.
Definitely.
Yep.
And to keep it rolling a little bit, so the SEC case is pretty much closed at this point, but we do have one outstanding issue, and I do want to pass it to Mr. Herbs because you have been doing the deep digging journalism that some of the journalists have been failing to do, and that is, of course, the red notice that was put up by Interpol, and the case is based in Finland. So, sir, what have you found, if anything?
Yeah, I really still have not been able to dig up anything other than, I was talking to Zenith about this yesterday. We when I started pulling the string on this sweater, I would contact some of the journalists directly that had written articles, and their response to me was like, "Well, I relied on this other journalist article to write my article," and then I contact that one, and it'd be like, "Yeah, well, I relied on this other journalist article to write my article." So, like, if you tracked it all the way back, you finally got to the one detective in Finland, and I contacted them or him directly, and he basically just told me to go pound sand. They don't have any public information there whatsoever. So yeah, it's just very difficult to pry any information out of Finland. This is so unusual to me because I can walk into any courthouse or just log on to Pacer and pull a criminal complaint for literally anybody that's ever been prosecuted by by a federal court, or if I walk into a state court, I can do the same thing, find out all the facts in that case that are listed in the complaint and say, oh, okay, here's what it's about. I can explain it to you now. I just can't get that out of Finland for whatever reason. It's just not a public document, which just blows my mind. So we're stuck. But I find it interesting that what it just came out recently. Somebody I wish I could credit them, but I cannot remember who it was. But they were able to find a press release by Quinn Emanuel saying that we help clients with red notices, and I'm like, oh, okay then. Let's just wait and see where that goes.
But yeah, as it stands right now, there's really not that much available information to the public. That's just how Finland operates. Again, we're US based, cases in Finland, so different procedures wherever you go. But I do want to throw it over to Mad Dog here shortly. If you go on the Interpol website and you look through the red notices, you'll see Richard Hart's mugshot next to a bunch of other people. But the big difference, though, is that it appears that Richard Hart is on there purely for what appears to be a simple assault case and tax evasion. Meanwhile, everyone else that is on that same list as him are there for much more egregious reasons that are probably not even YouTube friendly, to be honest. What do you think about Interpol's actions here?
Oh, absolutely, it's criminal, funny enough. But yeah, it's a political toy that they're using to try and get Richard. Obviously, there's no substance behind them. It's the same as when the court case came out. A quick read of the blurb, and anyone with the slightest bit of logical or critical thinking will go, that's an absolute load of rubbish. But again, it's like it's just it's a tool, it's a political toy bandied about for people who they don't want. But the very fact that he's on the Interpol red notice means that he's ruffling some feathers at very, very high levels. And there's someone, so he's doing something behind the scenes that somebody wants to stop him. So that tells me he's on the right track.
There you go. It does appear, based on everything available, that there's larger forces at play, because it appears that the amount of attention they're giving this for what is alleged doesn't quite match up there.
No, it doesn't match.
Regardless,
I agree with you. Like everybody, I don't know how many people have ever fought off have ever been told they owe money from whatever revenue place, whether it be the IRS or your local state, revenue seeking organization or whatever. But they don't throw you on a red notice for not paying taxes. It just seems like what happens is you have a conversation with them and you work something out, and that's the end of that discussion. So I don't get it. And then the other thing is if it's a simple assault that we're talking about, like, we don't even know the other side of it too, right? So, because we haven't been able to see the facts of the case. I mean, it could be literally self-defense and we have no idea. Because that would be a defense, which Richard would have to put that out there. But, since we don't, and who knows what actually happened, since there's no public information. So we don't know if he has responded to anything yet. So, it just seems like so silly. Like, you don't see red notices go out for these type of allegations. It just seems very disproportionate to the actual allegations that have been put out. So I'm not really sure what's going on, but it does have the smack of politics to it.
Yeah. Well, I mean, at the end of the day, we're just going to have to wait for more details to come out and for it to actually be adjudicated. So until then,
we'll know when we know.
Not much else.
And, he'll tell us when he's ready to tell us.
This is very true. I will say, up to this point, I think Richard Hart has been a very good legal client, which is that when you get sued, typically what you want to do is hire a lawyer, shut up. And it appears that he's done a very good job of that.
I would 100% endorse that. I would agree with that 100%. So.
For sure.
Just on another note to that, it's like there's a term that's bandied about: justice will prevail. Justice does not prevail. People prevail, and justice only prevails when people are prepared to stand up for their rights and fight for them. It's not a force field that protects everybody. If you have to be prepared to stand up for them for yourself. And just as a quick side note, I had a very useful case. I had last year. I beat the Ministry of Justice. I sued the Ministry of Justice, took them to their own court system at the High Court, and beat them.
Excellent.
Good for you.
There you go. People have prevailed, and by people I mean you. Well done, sir. Well, we do want to keep it rolling a little bit here. We did prepare a little bit more than just the RH case stuff because honestly, there's not much else to talk about at this point, especially for the SEC and also Finland. They're kind of at both sides of a fence, which is one's resolved, the other we're still waiting to see. So with that being said, we are going to jump back across the pond to the United States. And Mr. RHMax, if you're in the background, I do have a screen share here for you. When you're ready, good sir. Excellent. So talking a little bit about the crypto landscape as we see it in 2025 and what we think might be coming down the pike. We do have an article here from Cointelegraph. The Oregon State Attorney General, they have a lawsuit against Coinbase, and they're calling XRP an unregistered security. If you remember, there might have been another case. This one happened in the Second Circuit of New York, and this was back in 2023 when they ruled XRP was not a crypto security. So the question here is, what the heck is going on? Well, we do have the release from the Attorney General here. States must file enforcement vacuum being left by the federal regulators who are abandoning these cases under the Trump administration. Attorney General Dan Rayfield today filed a lawsuit against Coinbase, one of the largest cryptocurrency trading platforms in the United States, for violating the Oregon state securities law. The lawsuit claims that Coinbase has both encouraged and helped the sale of unregistered cryptocurrencies to people in Oregon. In doing so, Coinbase has reaped millions of dollars in fees as Oregonians have faced huge losses, often devastating, from risky investments in a market that's stacked against them and hard to navigate. Quote, after building trust with Oregon consumers, Coinbase sold high-risk investments without them being properly vetted to protect consumers, Rayfield said. Oregonians lost money, and we believe Coinbase should be held accountable and take steps to protect consumers, end quote. And then finally, down here at the bottom, this lawsuit comes as the SEC recently dropped its case against Coinbase and reassigned the lawyer leading the case to the SEC's IT office. Attorney General Rayfield says that the states must fill the enforcement vacuum being left by federal regulators who are giving up under the new administration and abandoning these important cases. So I guess the question to you gentlemen here is, what do you think is going on? Because we just got some clarity, even regarding the XRP, not that we particularly care about that one, but as far as crypto law goes, we actually had a ruling that the sale was not a security. Now the individual states are actually trying to retry some of these arguments in an attempt, what they believe is now an enforcement vacuum, because the SEC has actually backed off a lot of these cases.
Yeah, let me just to explain to everybody who may not be, may not be American as well. We have a federalist system here in the United States where we have 50 states that are allowed to make their own rules on a lot of things, and we have our federal government. So we've been dealing with federal law and SEC regulations, which is a creature of the federal government. But each state has its own laws regarding, protecting consumers and whatnot. And, they can issue securities laws if they want to. They can issue different rules for, whatever they want to, classify as a security or things like that. And this is only going to get fixed by legislation, which I actually want to talk about, kind of at the end of this, because there is, I just read I read pieces of the market bill that just got, they proposed. So there's a couple of highlights I want to go through, but the Oregon case is strictly brought under Oregon securities laws. It's not brought under federal law, so it's basically stuck in Oregon. You can't do what's called remove it to federal court, where they would, the Coinbase might actually have a better shot at defending this thing. This just seems like a money grab to me. The Oregon AG, when the SEC filed against Coinbase, I think they listed 12 or 15, the coins that they considered securities. The Oregon case is, somewhere in the neighborhood of like 25 to 30 different ones that they've listed that they think are securities. Including Solana, Filecoin, ADA, Matic, Near, XRP, Aave, Algo. Like there's a ton of them. Problem with getting the problem with getting complaints from Oregon is that you have to be part of the registered system or whatever. I was hoping to find somebody who would actually, had put up the entire thing. A guy named Justin Slaughter at JBSDC on X did a pretty good breakdown of what of this particular case, and put up some of the pleadings, or some of the pages of the complaint, and explain through them. So. It seems like it's just the AG, taking a shot, and I'm not really sure where that's going to go. But the feds put out what was it called? It's like a market. I forget what the hell it's called, but it's basically like a market structure type bill for security, for crypto assets, and vis-a-vis how they're going to be classified as securities. And some of the highlights in it, I could post the actual link to the market structure draft bill, but tokens basically aren't going to be securities, like by federal law anymore. They're carved out of federal securities laws as long as they're transferable and not reliant on a central party. Apparently, seems to be the point there. Secondary sales get a green light as long as the issuer isn't involved. It's probably not a securities transaction, so that is a huge relief, and basically would clears up a whole lot of what used to be gray area. And what it says is rule-based blockchains where no one owns more than 20% can be certified as mature, making their tokens digital commodities. So that's an interesting one too. So, given the fact that, Pulse has got 50,000 validators all over the world, not to my knowledge, nobody owns more than 20% of this, of the validator. So I think, we're gonna fall right into the digital commodities portion of that program if that market bill gets enacted. So fantastic news. If I think this just got introduced like a couple of days ago, so it hasn't really gone anywhere. But if this is what they're looking for and this is where they're headed, I believe that the bill had, if this is the same bill I'm thinking about, I might be getting the stable coin bill confused with this one, but there were 17 Republicans and 4 Democrats, so it is it does seem to be some bipartisan push, which is good for us. So let's keep. I'll keep track of this as it gets along and kind of goes through the entire process, and I'll give you updates as I find out about them.
Sounds good. So the reason that we wanted to mention this here is that as we're going into 2025, we have a change in administration, namely Joe Biden is out, Donald Trump is in. And we've also seen a good amount of turnover at the SEC, who up to this point has largely been regulating cryptocurrency inside the United States. As Mr. Herbs just mentioned, some of these things can be classified as commodities. And it does turn out that we have the CFTC, the Commodities and Future Trading Commission, inside the United States as well. So where the jurisdiction lies is actually kind of back up in the air. And we've also seen a new approach from the SEC now that Paul Atkins is in as the head. And they've actually been dropping a lot of investigations into many crypto projects that were originally started under Gary Gensler's leadership at the SEC, which is also where the Richard Hart case also originated. So the reason that we bring up the states actually trying to maybe step into some of these gaps is that we're entering an era where we're seeing a change in policy from the SEC. Previously, they were trying to do a lot of regulation through enforcement, aka lawsuits, investigations, that kind of things. So now I believe that we're going to start to see a shift back towards more a regulatory stance from the SEC, which some people might argue was the original purpose of the SEC all along. Those people would be me. The whole point of this is to say that we have a lot of things when it comes to crypto that are in the pipeline right now. There were a handful of executive orders that came from the president's desk back in January and February. And we've also seen some of those committees actually start to get some of their actions rolling. So we're expecting a stablecoin bill in August, primarily from Senator Tim Scott of the Senate Banking and Finance Committee. So that is in the works right now. Allegedly, they do have all the votes needed to pass it. But on top of that, we have a bunch of other unresolved issues, including the digital asset stockpile, or aka the Bitcoin reserve. And then we also have some campaign promises that were floated around there about things like US-based cryptocurrencies not being taxable under capital gains tax. These are things that we're still yet to see come down the pike, but that's at least what we have on the calendar for 2025. So me personally, I'm expecting to see less enforcement or less regulation through enforcement, aka lawsuits, and actually more rules being floated through the proper channels, vetted, and then implemented once they actually can agree on a final rule. Gentlemen, do you think I'm off base there or anything?
No, I think I kind of endorse that. It just seems to be the trend that's happening right now. So I think you're spot on with that analysis.
Fair enough. Well, that is what we have in the U.S. I do want to pass it over to Mad Dog because it sounds like you guys are dealing with some of your own tax ideas over there across the pond. What do you got for us?
Yeah, well, I'm going to be a little bit controversial here. Basically, there's again the European Union is chucking out all kinds of regulations here, there, and everywhere. The UK is pulling out different stops and talking. Generally, I don't pay any attention to it because it's all a load of fluff, and I don't really paid much attention to it because the idea I got into crypto was to avoid all that. I checkmate the matrix. I try and avoid the crypto industry is creating its own financial new financial landscape, and with crypto you can try and bring yourself out of the matrix and all the statute legislations and all that. And then, again, this is one of the things. However, I'll put a disclaimer in. I'm not legally qualified. I'm not legally trained. I've never studied a law at university. However, it's a pet subject of mine that I'm really interested in, and I know enough just to annoy the hell out of all agencies and all governments. One of my things that I'm working with at the moment is I'm working with one of the UK's experts on private trusts. And obviously, when you talk about trust law, then you come into equity jurisdiction. And obviously, as with the Richard Hart case, jurisdiction's a very, very important aspect of law. So a lot of people, again, like I said, I'm working with this guy. I'll give a little bit of an overview now, but I want to bring to the PulseChain some education about trust law, private trust, and how you can protect your crypto assets. So it's all about basically when you create a trust, it's asset protection. So again, it's a bit of a long subject. I don't want to go too deep into it, but it's basically anyone can create a private trust and you can put your crypto assets in and they will be untouchable no matter what the government says, no matter what statutes they bring out or new laws or whatever. You can protect your crypto assets if they are in a private trust. and myself and Peter are willing to come on and give a lot longer explanation to anybody that wants to have us on board, and we'll show you how to set up your own private trust, and also use the PulseChain tools like Lunar Shard to upload documents that are immutable and forever etched onto the blockchain with your own private trust, and immutable, untouchable, bulletproof.
Excellent. By the way, folks, please follow all the tax laws that are applicable to your local jurisdiction. And I think it goes without saying, nothing you've seen here today is actual legal advice. We'll give you some general guidance on get a lawyer and shut up. That one's pretty universally applicable. But if you're in the US and you're interested in a more advanced tax strategy, such as a private trust, you're allowed to grow your crypto inside of that trust as long as you're not self-enriching yourself on the way out, because that is where you do incur a tax. For more on this stuff, by the way, go check out Corey Geary's channel. He has an excellent team surrounding him, and they have created an excellent tax strategy regarding the use of private trusts. So if you're not interested in moving to Puerto Rico, this may be a viable option for you.